Hey guys, this is John Ween, attorney and senior legal instructor with Blue to Gold Law Enforcement Training, coming to you today with another roadside chat. Now today's question comes from an officer in Illinois, and the question is this. Let's say a restaurant or a bar contacts the police and says, hey, we've got a heavily intoxicated guy here, we want him removed. We don't want to aid in prosecution, we don't want him trespassed, we haven't asked him to leave, we want you to do it for us. And as soon as you go and you ask him to leave, he agrees to leave. Now the question is, what can we do with him? Can we detain him? Can we arrest him? And the issue that the officer's talking about here is he's saying we don't have any kind of a public intoxication statute. Nothing that we have on the books is an arrestable offense. And so can we detain him until he sobers up? Really, what you're going to be relying on here is the community caretaking exception to the warrant requirement, right? Terry v. Ohio, Katie versus Dombrowski, South Dakota versus Opperman, any number of cases talk about how law enforcement officers frequently engage in practices that, for want of a better term, may be referred to as community caretaking endeavors, right? Totally devoid from the investigation of criminal offenses. And so can we apply those not only to vehicles, but also to civilians, pedestrians? And the answer is yes. Vargas versus City of Philadelphia is a 2015 case on point here. Lockhart, Bembery versus Sauro out of the 5th Circuit. Samuelson versus City of New Ulm out of the 8th Circuit. United States versus Rideau out of the 5th Circuit. A lot of cases reference that Rideau case. It's R-I-D-E-A-U. United States versus King out of the 10th Circuit, United States versus Wallace, State versus Vistuba out of Kansas, State versus Marcello out of Vermont, State versus Pinkham out of Maine, State versus Oxley out of New Hampshire. Basically what we're saying here is that in the course of exercising a non-investigatory function, a police officer may have occasion to seize a person, as the Supreme Court has defined the term for Fourth Amendment purposes, in order to ensure the safety of the public and or the individual, regardless of any suspected criminal activity. Now what you want to do here is, if you are saying this person is impaired to the point that they are not able to care for themselves, they're not able to make their own decisions, what you want to do is you want to contact your brothers and sisters in red, right? Call them out, call those firefighters out to save the day, have them evaluate this person. If he refuses evaluation, then have them contact the doctor and say, hey doc, this is what we got. And if that doctor is then ordering them to detain him, take him in for a physical evaluation, well then that is going to be the process by which you want to proceed. So again, it's for a non-criminal investigatory purpose, but rather it's for a community caretaking purpose to protect him from himself, from his state of impairment, from his level of intoxication, or the danger that he represents to others if he goes wandering off into the roadway. Make sure you guys check the comments below for those case sites. Hopefully this helps. If you guys have any other questions for us, bluetogold.com/show. bluetogold.com/show. If you are interested in having Blue to Gold out to your agency, please go visit our training catalog at bluetogold.com. Until next time, this is John Ween, attorney and senior legal instructor with Blue to Gold Law Enforcement Training. Be safe out there and make good case law.